Look in the camera. Hi, guys. Please join the Patreon. Now, Judge, I named it the Real Dana Network, and then I have a tier, Judge Joe Brown Uncensored. But I think I'm going to just have one tier, right? Because the whole thing is uncensored. And I'm going to name it the Real Dana and Judge Joe Brown Uncensored.
Tune in for the first episode of Judge Joe and Dana After Dark.
That's a good one. So, guys, go click the Patreon link below and become a member. We are building a Patreon community so that me, and especially the judge, can talk about things that he cannot talk about on YouTube or anywhere else. The reason why he gets flagged and banned, he will be discussing it on Patreon. And then I will be uploading my life when I go to the gym and stuff like that, if you're curious. But join the Patreon of Judge Joe Brown and the Real Dana.
I promise I won't do anything like that.
All right. And that's it. We are done. All right. So listen, here we are with a special edition of Injustice for All. We got to talk about the Supreme Court hearing the arguments on the transgender athlete ban. It happened on oral arguments took place on the 14th or the 13th of this week. No, the 13th. Tuesday, yes. And it says Supreme Court appears likely to uphold transgender athlete ban. So the Supreme Court on Tuesday seemed likely to uphold laws that prohibit transgender women and girls from competing on women's and girls' school sports team. After nearly 3.5 hours of arguments in a pair of cases from Idaho and West Virginia, a majority of the justices appeared to agree with the states that the laws can remain in place, even if it was not clear how broadly their ruling might sweat. The court's 3 Democratic appointees appeared to recognize that the challengers faced an uphill battle. They seemed to devote much of their efforts to mitigating their losses, either way, by getting one case thrown out or by limiting the court's decision to narrow one. Idaho adopted its law in 2020. West Virginia followed 1 year later. Lindsay Heacock, now 24 years old, went to federal court in Idaho to challenge the state's law. Heacock is a transgender woman who wanted to be able to try out for the women's track and cross-country teams at Boise State University. She did not make those teams, but later played club sports. West Virginia case was filed by Heather Jackson, the mother of PBJ, a now 15-year-old transgender high school student who has publicly identified as a girl since the 3rd grade. PBJ has taken puberty blockers to prevent the onset of male puberty, as well as hormone therapy with estrogen. PBJ has competed on track and cross-country teams at schools. Federal appeals court in San Francisco barred Idaho from enforcing its law. The U.S. Court of Appeals for the Ninth Circuit agreed with Heacock that laws violates the 14th Amendment's Equal Protection Clause because it was intended to categorically ban transgender women and girls from public school sports teams that correspond with their gender identity. The law also discriminates on the basis of sex. The panel concluded because the athletes on girls and women's sports, but not on boys and men teams, are subject to invasive sex verification procedures to implement the law.
Actually, you're giving me the conclusions of somebody probably in their mid-20s that took a few courses in law and has very little expertise in the subject. Let me break down what was going on. You heard from Conjay Jackson why she couldn't tell anybody what a woman was when she went through her confirmation hearings, because she was trying to claim that anyone who thought they were female was entitled to be a female. I refuse to dishonor women by calling a faux item the real item. Woman is an earned category, like man is an earned category. Male is just what you're born as, female, just what you were born as, and that's a basic requirement. What's going on here is this: it's specious because there have to be categories. For example, you are obviously discrediting somebody or discriminating against somebody who has visual acuity problems. In other words, you can't and should not get a driver's license if you're blind. All right? Why? Because you can't see to operate the motor vehicle and you endanger anybody else on the roads. Well, if you're not female, you don't need to play in female sports because you are not a female. You may claim to be one. You may have all sorts of delusions that you're one. You may have mental health issues that make it firm in your mind that you are one. You may have always wanted to be one, participated and identified as one, but that does not make you the real deal any more than the other situation that comes up. You can make money to look like real money, but if it's not the government issued kind, it's counterfeit. And you can counterfeit movies, you can counterfeit music, you can do all sorts of things, but that does not make the counterfeit item the real item. So that was skirted around, and Jackson and the two liberal females on the court looked like they really, really were upset by this whole thing, and their tone of voice kept making certain assumptions that are not proven by anybody's fact. Like they kept referring to normal women as cis females and trans women, which I thought was at least mildly insulting, at least in tone, if not in concept. But that's all right. And then the whole thing about whether girls can compete on boys' team is like, if you can do it, you can do it. But the problem is that there are really some dichotomies between male and female that this particular agenda does not want to recognize. It's called sexual dimorphism. You go to a zoo and you see the female gorillas and they weigh about 150 pounds. A real big one might be 200, but the males are 600 to 800 pounds if they're the big silverback mature males, and there's an obvious difference. You go over into the same primate section and you look at the chimpanzees, and there's an obvious size difference between the male and female chimps. Same thing with humans. You may see females taller than males, but there's this whole thing about body structure that makes the typical male who deals with male standards of fitness, say being a soldier or something, a bit more formidable in the physical sense, in spite of Hollywood martial arts movies to the contrary. And that has to be taken into account. And as a personal anecdote, I am acquainted with someone who is a tenured college professor in California, fine lady. I know her well. She used to date a brother of mine, and he's now deceased, and she was a mistress of martial arts. She fought full contact back when it wasn't a popular thing, and she had 30 some bouts and run four of them by knockout, and got decisions on the other four. She was an expert with the screamer. Beautiful looking woman too. And she always said, hell, if somebody male is after me, I don't care what I know, I'm calling somebody else. She usually wanted to call Cliff Stewart, who was quite a big man to take care of it. So there are acknowledged differences in spite of those not dovetailing with the agenda of the theology of that cult, the rainbow cult. But now we heard people saying, well, these are realities. What are you going to do? If you sit there and allow this, all the guy has to do, if he's a failed male athlete, is claim he's a female and he can compete against the girls. So where did your girls' sports go? We have a division into male and female sports because it's just impossible for the girls to compete on equal terms with the guys in certain kinds of sports. And then several of the conservative justices put the nail in the coffin, so to speak, when they said, well, how about this one? Since we can't discriminate, what if some ordinary straight guy, and then one of the female justices seemed to have been offended by the word straight. He said, what if a straight guy who's not a very good athlete, can't make the varsity, decides he wants to play in girls' sports? Do we let him? No, we don't, because he can't cut it. So why does it make it okay if he just says, I'm a girl?
I want to play a couple of clips from the hearing.
States have long assigned students to sports teams by sex. West Virginia is no different. Maintaining separate boys and girls sports teams ensures that girls can safely and fairly compete in school sports. The question today is whether this enduring structure can continue. It can. Title IX permits sex-separated teams. It does so because biological sex matters in athletics in ways both obvious and undeniable. The text, history, context, and structure of the statute, alongside regulations expressly authorizing what West Virginia has done, confirm as much. Respondent says that West Virginia schools can no longer designate teams by looking to biological sex. Instead, schools must place students on sports teams based on their self-identified gender. But that idea turns Title IX, a law Congress passed to protect educational opportunities for girls, into a law that actually denies those opportunities for girls. The court should not embrace that backwards logic. Aside from its problems with Title IX, the decision below constitutionalizes one side's view of a hotly disputed issue. But West Virginia's law does not offend the Equal Protection Clause either. The West Virginia legislature reasonably and rationally defines sex based on biology and acknowledged the physical differences that biology creates. Given those differences, the law satisfies rational basis review. And the state's law satisfies even intermediate scrutiny because it is substantially related to the important governmental interest in ensuring fairness and safety in girls' sports. Respondent attacks the law by searching for a transgender classification that simply isn't there. The law is indifferent to gender identity because sports are indifferent to gender identity. Ultimately, West Virginia's law, like the laws of at least 26 other states, simply preserves the enduring structure on which girls' sports depends. It should be upheld. I welcome the court's questions.
What's your view of what Title IX, how it defined the separated sexes, male and female?
So under Title IX, Your Honor, we would look to the ordinary understanding of sex at the time that Title IX was passed, 1972, and I think also relevant would be 1974 when the Javits Amendment was passed. And at that time, the ordinary understanding of sex was biological sex, consistent with the understanding of sex reflected in West Virginia's statute. I think that's also consistent, frankly, with this court's own understanding of sex and some of its own cases like Frontiera, where it likewise focused on things like reproductive function.
Well, with that definition, how would you square this challenge with the continued existence of Title IX?
So I think this challenge fails under Title IX, and in fact, it amounts to a backdoor attack on Title IX, in the sense that Title IX itself contemplates sex distinctions, and express regulations specifically applying to the context of athletics expressly contemplate the distinctions between sex of male and female sports teams.
So in interpreting this definition, would it make a difference, or does it make a difference that this is a spending clause statute?
I think it absolutely does, Your Honor. Obviously, in the spending clause context, as this court has somewhat recently reminded lower courts, it's important for Congress to speak with an even clearer voice because of the contractual nature of the conditions that are imposed. States like West Virginia have to understand exactly the obligations that they're assuming in the context of the spending clause analysis. And so
Hold up a second. This is getting way complex for the general audience about the spending factors here. In other words, it's got to do with Congress is paying out the money. They can set the terms within constitutional limits of how it gets spent. So this is going to be a distraction. It's just like the conservative justices seem obviously to have said some of us are going to focus on different aspects of this issue and we're going to deal with it, the whole thing, or as much of it as we can. So this is just a matter of arcane technicality. So I think we can skip the discussion about the money aspect of the thing. That'll go way over people's heads.
I'm sorry. I presume that if it's statutory construction, a canon of statutory construction, it's hard to say you can waive that?
it's very hard to say you can waive that, Your Honor. Yes.
I just wanted to ask if, on your understanding of Title IX, you could have separated by sex classrooms in biology or in math based on some evidence that you have that say men are better at math and science. What are the limits to your Title IX theory?
So I think your instinct there in part arises from the fact that we're skeptical of any notion that there are inherent differences. So I want to kind of acknowledge the real reality of this.
Well, your whole position in this case depends on there being inherent differences, right?
It does, and I think that that's exactly why discrimination.
Right here, this gets specious. See, in other words, where you say boys are better than math than girls, or girls are better in this than boys when it comes to an intellectual thing, you have an exclusively subjective standard of evaluation as to what's better. That gets into taste. That gets into other fine points that are not subject to a rigid analysis. And it makes certain assumptions that may or may not hold sway in the real world. But when you come to what they're talking about with sports, there is an objective standard. Even the shorter guys tend to weigh more than the girls, except the fat girls. The world's record, 100 meters, is held by Usain Bolt, as is the 200-meter record. The 400-meter record is held by a man. The 1,600-meter record is held by a man.
For clarity,
all of the sprints are held by men because that's not subjective. There's a stopwatch going on it.
But one second, Judge, 1 second, because it's not about, this is about transgender girls and women wanting to go in girl sports.
Yeah, but see, it's specious because it's an artificial category that is linguistically based rather than factually based. Right now, the census scientific research suggests that less than 0.5% of the American public is transgender. So you're trying to go against the interest of 99.95% of the American population. And that's what these liberal justices keep skirting around. They won't deal with the numbers. Yet the Supreme Court has said that statistics are very important. And as a matter of fact, it does come up in the discussion, which went on for hours. But this is the thing right here. Boys and girls are physically different. It's called sexual dimorphism. It is a characteristic of the human race, the species, the characteristic of pan troglodytes, aka chimpanzees, and the same thing with gorillas and some other primates. It's also the thing with lions. Males have the manes, the females don't. And the females aren't as big. It's an inescapable fact of nature. Now, when you take a stopwatch and you put it on somebody's time, there is not going to be any question as to the differences. Old time football, until they softened it up, was pretty brutal. People died regularly from it, which was part of the attraction. It was dangerous. Now, you don't particularly want to say you let somebody who can hang with the brutality of old time football, male, be allowed to play with the females. Just imagine if you had some sissy who was 6'5" and 270 pounds and he got cut from a pro team because he couldn't cut it. You're going to let him because he now wants to wear panties, bra, and some tights. You want to let him play in a female league and he's 270 and 6'5", and you want to let him play against the girls. That's not right. Somebody will get killed. And see, that's the other thing. Women get physically injured all the time. I have a family friend that got her arm broken in 3 places and had a hard time continuing to be a student due to pain medication because she was required to wrestle one of these freaks who identified as a girl, or her team would forfeit in the state wrestle off. She was in the martial arts, so she got into female wrestling full contact. But you see, there are some drawbacks to this whole thing, and this crowd, Kanye Jackson, et cetera, don't want to acknowledge it. So I can see the 3 liberal females on this panel, and perhaps Justice Roberts getting in, so it's 5-4, or him not getting in on this, and it becomes a 6-3 decision. It is an obvious effort by those who have been carefully groomed to sit on this Supreme Court to push this rainbow thing. And that's why you saw Kanye Jackson scratch her head, and when asked a question by another woman, said she didn't know how to define a woman. She does, because it's what you want to be rather than what you are in her definition. And that's the whole thing. If you want to be a girl, then you should be allowed to play as a girl, but there's no way of ensuring that somebody is telling the truth and is not just lying to get advantage. And see, what also is coming up and is alluded to, what about in the job market and women's rights? Well, women should have an equal opportunity to work, but what happens if some guy who doesn't get the job has to do is claim falsely that he's a woman? Who's going to prove him different? So what you do is you knock the women out of fair employment. You knock the women out of a fair opportunity to engage in sports. And that's what it's about. And you come up with the ancillary thing, which is, do these guys get a limit on the facial hair so, their adolescents, they're growing it before they aren't allowed to take naked showers with the girls or piss in the girls' bathroom?
You want me to finish playing a clip?
Yeah, you can, but that's what we're here for, and it's back and forth. Everybody's being polite instead of saying, hey, you guys are full of shit. You represent less than 0.5% of the population. You're trying to rely on this thing that dealt with a significant proportion of the American population and a long history of malfeasance, having to deal with the treatment that Black people and Native Americans, Indians, got at the hands of the mainstream European settler over here. So that inequity got changed. So don't try to sneak in here with this little subjective thing. Just has to do with your perversions. We can't screw American law that impacts so many millions of people just to satisfy less than 0.5%.
Title IX context, where it acknowledges merely inherent biological differences, that's not discrimination, that's a distinction. And I think that's consistent with this court's longstanding understanding of what discrimination means. It looks to differential treatment of similarly situated individuals. So even in a case like North Haven, you're talking about differential treatment of similarly situated individuals. So if we're talking about in an athletic context, you're not addressing similarly situated individuals. And I think, again, the Javits Amendment and the regulations that flowed from the Javits Amendment are a realistic reflection of those meaningful biological
The
differences.
Javits Amendment gives you a reason in the sports context maybe
Right.
to do it. I'm just wondering whether, your friends on the other side have basically conceded that Title IX allows sex-separated sports teams, so I don't know that we need to really get into that. I'd be a little bit concerned about what the ramifications of that might be. And the Javits Amendment, in the context of sports, makes a difference anyway. But more broadly, I mean, if a state produced some studies saying, listen, women's presence in, calculus is holding men back because they're so much more capable and they can just move so much more quickly. Seems to me like there'd be some risk on your understanding that that would be okay.
I think, again, realistically, Your Honor, that would almost certainly fail on the lack
How
of...
about chess club?
A chess distinction, I think, again, might fail because there's an actual lack of evidence of meaningful physiological differences that are reflected in the existence of the express regulations in the athletics context.
I mean, I think a lot of people.
I'm timing this. We might run into some intellectual property problems if we keep playing too much.
No, this is going on Patreon, so it doesn't matter.
Well, they still get there in the United States. That's Article 1, Section 8 about intellectual property.
Well, not with this channel because it's fair use as well. But so this clip here is Kanye Jackson. It's about 6 minutes. I don't have to play the whole thing.
I really have a problem listening to her.
I know you do. That's why I want to play it so you could break down her ignorance. But you could tell me when to pause and stuff like that. Okay.
Okay, well, let's go.
Thank you.
Justice Barrett. Justice Jackson.
So I guess I'm trying to puzzle through whether or not there is some independent form of discrimination against transgender women that is distinct from sex separation.
Stop. She is making an assumption that there is such a thing as a legitimate woman who becomes such because a transgender claims to be that. See, one of the things in here is there's no scientific proof that says that. And then remember, she can't personally define what a woman is. So her description may bring in her particular limited judicial notice of what she thinks a woman is supposed to be, which is just something somebody claims to be rather than what they actually are. Because as several of the conservative justices point out, what happens if a male falsely claims to be transgender? Does this person get to take advantage of the benefits that accrue to being a physiological woman?
Okay.
Title IX allows. So I appreciate that your argument is that because the regulations permit sex separation and that hasn't been challenged, that should be the end of this inquiry, basically. And I think you get there because you say you're sort of picking up on this idea that maybe this is just about a definition of who is a male or a woman. Is that right?
I think to some degree, but it's also, Your Honor, it's just because we're indifferent to a person's gender identity in applying the law.
But the law actually operates differently, I think, for cisgender women and transgender women. That is, with respect to their desire to play on a team that matches their gender identity, cisgender women can do it, transgender women cannot. And so we do appreciate a distinction, I think, that is being drawn on the basis of your gender status, gender identity status, trans or cis, right?
So, and I want to make sure I understand if we're operating in Title IX world or equal protection world, because I think it might make a difference to the answer, but.
Okay, let's start with Title IX.
So Title IX, I think the question of, I look at this statute and see a distinction between boy and girl indifferent to gender identity. And I think that...
Right, but I'm testing that proposition, right? You see that distinction, and I see it too on the separation of teams level at the beginning.
Right, and I think what I'm hearing is that distinction arises from a difference in effect, and I don't see a disparate impact analysis that's sort of hidden away in Title IX.
But why is that a difference in effect? So it's like a second order discrimination, right? The first order is separating male from female.
Right.
The second order is separating transgender women from cisgender women, right?
Respectfully, I would disagree,
No.
Your Honor. The reason why is just because I think anytime you have a classification, you could divide it into subclassifications, and I don't think that then becomes, like, the law in the same way applies to brown-haired biological girls and blonde-headed biological girls.
I understand, but I don't think you can get,
based on hair color.
I'm not sure, and maybe this is switching to the equal protection, I don't think you can get out of the implications of making a classification by setting it up as a definition, you know, as a subclass. And so we've already okayed the classification because it's really all about classification. You can't distinguish in that way, right?
Well, I think what the court said on the equal protection side is you look at the facial classification, and I think here it's effectively unconceded that the facial classification is between boy and girl. And I think at that point, if maybe you have a situation where you think that the classification is somehow a proxy for some sort of secret secondary classification, but I don't.
No, but the definition implicates another division. So here's an example. So suppose that we have Title IX exempting, and I think it does this, certain religious institutions from its requirements. And let's say Title IX then went on to define, this is in my hypothetical, religious institutions to include only those institutions that proselytize. I mean, is that a classification problem or a definition problem? I would say it would be a classification problem, and you'd still have to apply all of the heightened scrutiny just because, you know, they're defining religious institutions in a certain way. Similarly here, you have the overarching classification, you know, everybody has to be, play on the team that is the same as their sex at birth. But then you have a gender identity definition that is operating within that, meaning a distinction, meaning that
Stop.
cisgender.
Stop. See, right here is obfuscation, trying to obviate the real biological differences for somebody's claim, which can be delusional, can be based on matters of perception, can be based on emotive reactions to a circumstance that are the result of mental health issues outside of just plain delusion. See, this presumption that what they say is in fact the case, and the overwhelming scientific literature and opinion on the matter is it ain't that way. You do not become a biological female because you want to be one. So you change the definition to saying female includes those who just want to be one, and you defeat the purpose of the general classification, which is crazy because you wipe out the whole basis for protecting women from discrimination. But anyway, let's go on from there.
Ginger girls they can play consistent with their gender identity. For transgender girls, they can't.
So I think that, okay, so as to the part about your ability to pass over from boy to girl,
Yes.
you can go from one way but not the other. I want to be clear that BPJ is not challenging that specific classification. I think that's important to start with. But I think, if anything, that's useful evidence as to the lack of a transgender-based discrimination, because if the legislature were just sort of unsettled by the notion of transgender athletes, I think the answer would have been to then bar them from passing over in any way consistent with their gender.
I appreciate that. I guess I was getting at the, what I understood the Chief Justice to be trying to discuss, which was this notion that this is really just about the definition of we accept that you can separate boys and girls, and we are now looking at the definition of a girl, and we're saying only people who were
Stop a second.
Girl assigned.
Stop a second. Now, isn't that obvious to most sane people that boys and girls are what they're born as rather than what they claim to be when you start talking about a need to segregate them so that each can have a fair opportunity to do what they do when there is a demonstrable, objective way of determining performance? In other words, who wins, who's fastest, who can jump the highest, et cetera, et cetera, et cetera.
Right.
Now,
It's just a couple more seconds left.
At birth, qualify.
And there is authority cited in our brief. This court, I don't think, has ever phrased it quite as in the way of this definitional framing that we're talking about right now, but certainly cases like Jana Rock in the Second Circuit do approach it from this sort of definitional framing, and they say that if you effectively concede that there's an initial ability to draw a classification, then that suffices to satisfy the intermediate scrutiny question. But then
Stop. He's being crystal clear here. That's correct. If there is a basis for the classification that says, okay, we can divide this into male and female sports, then you can't defeat the rationale by coming up and saying, oh, but we want to change this. These guys that ordinarily would have an unfair advantage because they claim that they are part of the protected class, they should be allowed in. See, that defeats the whole purpose. Women should have equal employment opportunity, but these males over here that identify as girls, they should be included in the female category. So for every one of them, you diminish a real member of that category that is to be protected.
Definitional question is evaluated through rational basis review, and that's Jana Rock. I recognize this court has never gone as far as that, but I don't think the court needs to go as far as that because, again, I think the way that you would do the analysis is to start by looking to the face of the statute, and if the face of the statute is engaged in a conceded boy-girl sex classification is conceded to be legitimate, then at that point, you kind of know which world you're operating in.
Thank you.
Thank you.
In that argument, does it matter?
And so this one here,
she might, if she thinks about the logic she just helped develop, she might go along with what's going to be the majority. She might surprise you. I doubt it, though.
so Ellen Kagan grills attorney on if it matters if a trans athlete has a competitive advantage or not.
Well, then why have girls' sports in the first place? That's why.
Whether BPJ has a competitive advantage or not?
Yes, we think it does, and I appreciate the opportunity to clarify that we don't have any objection to vacating the grant of summary judgment in our favor. We did our best to defend the judgment below, but our argument before the Fourth Circuit for summary judgment was that there wasn't a genuine disputed fact about whether she had an advantage. The Fourth Circuit, sua sponte, granted summary judgment to us based on the theory that that fact wasn't material. That's never...
Sua sponte means on its own. Nobody asked them to raise it. The justices looked at it and said, oh, we have to do this. This occurs to us. That's what sua sponte means.
Been our argument in this case.
So your argument depends on the depends on her not having a competitive advantage because she's not been through male puberty.
And not just not been through male puberty, but also gone through a female hormonal puberty
Right.
with all the physiological changes accompanying it.
But that the argument goes away if those facts go away.
Yes, absolutely. Which is at the beginning of the argument, Justice Kagan, you talked about.
Stop. There is another thing that comes up right here. How concerned is organized sports with drug use? So how ridiculous does it sound to say sports has to be vigilant against giving an advantage because of the use of drugs, and then turn around and say, but you have to use drugs to give you a disadvantage so you can drop down to the B team. You see, that's preposterous and it's absolutely ridiculous, but these folk want something so bad they never thought about that.
Could be resolved based on a legal principle or based on the facts. And I really do want to make a pitch for the resolving it based on the facts because, look, if they're right about the facts, then we should lose. And the irony is that in order to win summary judgment in this posture, when there's a disputed question of fact below, is they can only win in this posture if we're right about the facts and there aren't any advantages. And I don't think there's any need at this juncture for this court to issue that broad a holding when, according to them, once the evidence comes in below, we're not going to get past summary judgment. I mean,
You're not suggesting that we decide the factual question.
No. I'm suggesting that the case be allowed to be decided on remand on the factual question, which I think, look, this is an important issue. It may affect the whole country, and the court wants to get it right. And I don't think the best way to get it right is to rely on, cherry-picked studies or assertions in amicus briefs. I think the way to get it right is to let all the facts they're trying to put in the record actually be put in the record. And then we'll have the facts in front of us, and maybe they'll make the issue go away. But I think that's unnecessary to intervene at this instance with a sweeping legal conclusion to something that might actually be a narrow factual dispute.
With Purdue Global, education fits your life.
It's like 2 more clips and they're like under a minute.
Yeah, well, you see, you're getting back to reality interjects its hard head into this soft, nebulous, emotive thing.
Mrs. Kavanaugh? Mrs. Kavanaugh?
There are, as we've discussed, a bunch of states that allow biological males who identify as female, transgender women and girls to play women and girls sports. We were talking about that with the Solicitor General earlier. On your theory of Title IX,
Right.
are those states violating Title IX rights of the biological females?
I think it's a much closer question under Title IX than it is under equal protection. And I think the reason being is that the regulations specifically say what
do you think the answer is under equal protection? I might as well ask that.
So under equal protection, I think we agree with our friends in Idaho that there's enough room for California to make a different determination.
Okay.
I think under Title IX, the reason why it's a closer question is because of the existence of the regs. And the regs start by saying you start with co-ed teams, and then you can move down to sex-separated teams in the context of contact and competitive skill. And it really contemplates a real, genuine sex distinction in that move down B provision. Mm-hmm. And then, of course, it pivots. It also has the catch-all where it says, but actually in the contact sports, you can't even, you can't move back in the co-ed world. So I think if a state is moving away from a genuine sex distinction as the regulator contemplated and as Congress ultimately contemplated, then maybe they're kind of, if you think of B as a safe harbor in a sense, they're outside the scope of that safe harbor, and now they're running into the problem in A. So I don't think the court needs to get into any of that.
Right, I agree. I'm just trying to know what's coming.
But I think that it's a closer question at least than the.
Because your theory is that sex is biological sex in Title IX, or is that not your theory?
No, that is, and it's not our theory, Your Honor. It's just it's the ordinary understanding of what sex meant, both in 72 and 74 when the regulations were themselves implemented. So I think we're just trying to be consistent with that.
Thank you.
Makes good sense.
Yeah.
But some people don't want to deal with that because
Well, you're right, obviously, that
they don't want to deal with common sense because it counters their agenda. It does not fit their narrative.
I think that was that. No, it was this one.
I would have thought that's an interesting argument, that this is spending clause legislation in Title IX, and Congress has to speak with a particularly clear voice, and whatever it said here isn't clear enough. You didn't raise that argument. And there's an argument from your friend on the other side that you waived the argument, or forfeited it at least.
Right.
And it sure isn't the lead argument in your brief. Help me out. Why?
So we, of course, start with the plain text of the statute, Your Honor, as this court has told us to do several times.
Yeah, well, I might start with the constitutional authority under which that statute was adopted, counsel.
I think that's equally compelling authority for our understanding of the
equally compelling, the Constitution equal.
Perhaps greater compelling.
I would have
authority.
thought, yeah.
West Virginia, as you know,
why isn't it in your brief?
West Virginia is maybe uniquely a fan of clear statement rules, as Your Honor might know from past cases. But in the spending clause context, I think it is in fact the case that your court has repeatedly stressed that Congress has to speak with that exception.
I know what we've said. I'm wondering about what you didn't say.
So I think if you're looking at the way that West Virginia has characterized it, certainly we have made that argument and presented that argument to this court. I'd refer you to the topside brief. It's clear and centered under a clear heading. As I think what their suggestion is from the other side is that we didn't clearly enough raise that argument below. We would take issue with that characterization. There was obviously binding contrary authority in the Fourth Circuit. And so I think strategically we decided not to make that the front and center argument because we understood that was dead on arrival in that particular court. But that's not to say that we waived the issue by any means. It's a canon of construction that continues to assist this court in its application of the text of the statute.
But and basically, what is the other side that wants the transgender girl and woman to be able to play in girls and women's sports?
I will not use that term, transgender woman. Transvestite is better because woman in this instance is referring to a counterfeit item, a faux woman, not a real one.
Right. So again, what is that side? What is really their strong defense? They
don't have one. It's all desire.
Right. So I desire and I identify as a woman, so I get to play in women's sports.
Yeah. And that's like they said, well, what if you are a guy who's not good in boys' sports, but you're not this weird, you just want to play with the girls? Can you go in and play? And then the justice pointed out, wouldn't that be discrimination against this straight guy?
And here's my other question. Why?
And he said what it would do then is completely destroy the argument that says you can have separate girls and boys sports. Wouldn't that be a setback for women?
But here's my other question. Why is the focus on transgender being in women and girls sports and not boys and men's sports?
Because the point is the girls have girls sports because they can't compete in co-ed sports where it's all out. Think of it. Football, you got to be able to deal with the potential for having somebody, if you're trying to play on the line across from you at 6'5", 270, and can bench press 300, 350 pounds. Can you take that person on in a beat them up, knock them down?
Oh, wait a minute. So if the LGBT community or the trans community lawyers, if they have it their way, a heterosexual boy who is wimpy and can't compete with other boys, he may be allowed to compete with the girls, even though he don't identify as a girl, but because he's weak to compete.
Exactly. They call it.
So it opens the door for that. It opens the door.
Yeah, and you defeat women's sports.
Right.
See, that this whole thing is not logical. And what happens is if you go for it, you tear up women's rights. Women have worked a long time trying to get into having women's sports so they can get scholarships to go to college, so they don't have to pay out big money.
Right. Exactly.
And these clowns are so selfish that they'd be willing to give it up. They'd pillory the women and say, screw you. We just want to play in our little sissy league. So this is a way we can't make the varsity. So let's go out here and play with the girls. Just put on some panties and a bra, sports bra.
All right. So that concludes that. Real quick.
It's a slam dunk, actually. The only reason it has any traction is because of the presumption of legitimacy going to an illogical position. There is there is some scientific proof, but it's crank proof. In other words, it's the kind of stuff where a known scientist says the ancients were right, the world is flat.
Right.
That's what they have in support. So it's kind of sort of, this doesn't make any sense.
So we're done with this topic for right now.
Yeah, I think it's going to be a 5-4, 5-6, a 6-3 decision in favor of upholding the ban for the freaks in the girls' sports.
All right. I want to move on to